Good morning. I'm going to talk about some practical issues relating to trust today. Some people say they don't like trust anymore because look at these potential tax changes. Relax. As Eddie Bloomberg said, the modern Midas, everything that you touch turns to tax. So don't be guided by tax issues when it's far more other important considerations to have a trust. You know, we've had the Income Tax Act since 1962. I think that's when Philip celebrated his 21st birthday. And the laws are changing all the time. And as things change, we change as well. You know, you outthink these people. So, you know, for example, if they, at the moment the trust is a conduit, income flows through the trust to the beneficiaries, and the beneficiaries can be taxed. If they're going to ring fence it and get the trust to be taxed, let's start thinking, you know, maybe we distribute the right to income to beneficiaries. Leave the asset in the trust, distribute the right to income, and you bypass the trust altogether as far as the income is concerned. So there are lots of things we can think about. So let's look at the practical issues as to why you have trust, because the real reason why you have a trust is asset protection. You protect children as well from their own indiscretions, like marriages. And unassociated with tax, good reasons. So what am I going to talk about? You're only a little bit later. But the first thing is, you know, it's a good starting off point. What is a trust? You know, it's that Romeo document most of you have, which they changed a few names, then put your names in there. That's what a lot of trusts are. But it's much more to that, of course. Problems with trusts. You know, you think your assets are protected in a trust and you've got a trust. 90% of these so-called trusts I can attack and say, oh, those are your assets. That's what I want to talk about, problems with trusts. The parties to a trust, a very useful party is a protector. You can have a protector in South African trusts as well. You know, become a trustee very reluctantly because you have very serious duties as a trustee. Whereas as a protector, you don't have those statutory duties. As a trustee, you've got to be diligent, skillful, careful, all the rest of it. And then the final thing I want to look at is, when can you actually attack assets in a trust? There are 4 different circumstances, and they're very different, which I've sort of summarized, as to when you can actually get your hands on a divorce or creditors go into that trust and seize those assets. So the first thing is, what is a trust? Now, a trust is defined in the Trust Property Control Act, but that doesn't mean to say those are the only trusts that exist. So the Trust Property Control Act identifies 3 types of trusts. There is the family trust, which is an ordinary trust which we use for financial planning for asset protection. There's the charitable trust. There's also a bevint. The difference between a bevint and an ordinary trust is a question of ownership. Because, for example, a bevint is I bequeath my assets to my minor child. Until the minor child reaches 21, the assets will be under the control of trustees. That's a bevint because the minor child has ownership. Now, what sort of trust do you have? Do you have an ordinary trust for asset protection, or have got a bevint, or don't you know what you've got? That's the trouble. Most people don't know what they've got. Because the critical difference is, if you own the asset and you get divorced or you go insolvent, that asset falls into your estate. So you've got to really know what kind of trust you have got. Is it an ordinary trust or is it a bevint? So let's start off with the definition of a trust in the Trust Property Control Act. A trust is an arrangement that's brought about by contract inter vivos or by last will and testament, testamentary trust. So it's an arrangement, a contractual arrangement or a last will and testament arrangement. It's not a person, it's an arrangement. And this is the critical issue. People make mistakes by thinking a trust is a person. For certain specific issues, a statute will define a trust as a person. For example, the Income Tax Act defines a trust as a person, so for income tax it is a person. The Companies Act defines a trust as a person, for a Companies Act it's a person, but if it's not defined as a person, it is not a person. And people make mistakes with that. And then the critical thing, this is your family protection type of trust, where ownership and control is with trustees, and they control and own on behalf of beneficiaries. There has to be this separation. You know, people don't like to give up control. And a trust is simply not suitable for someone who wants to keep control of those assets. You're wasting your time if you're controlling those assets. It's not a trust at all. Just because you call something a trust doesn't make it a trust. You look at the substance, you look at the facts, you look at how it's administered, you look how it was formed, and then you work out if you've got a trust or not. So the critical issue, ownership and control by trustees on behalf of beneficiaries. There must be that separation. And if you start putting these two together, you obviously have full ownership of those assets, and there is no trust at all. So I will talk about the question of ownership just now. It's by virtue of a trust instrument. This is the definition of the Trust Property Control Act. So in other words, if you want a trust in terms of the Trust Property Control Act, it has to be a written agreement. It has to be in writing. There's got to be a trust deed, which opens the door, because once you fall under the Trust Property Control Act, before trustees, for example, can act, they have to be authorized in advance by the master. But if you have a trust that doesn't fall under the Trust Property Control Act, you are not bound by the provisions of the Trust Property Control Act. So, for example, there's nothing wrong with you having a verbal or an oral trust, which I will talk about just now, which can be extremely useful, especially in emergencies, where you can vary an existing trust or create a trust verbally. And then later you can put it in writing, and then it becomes governed by the Trust Property Control Act. So it's an arrangement, ownership, and beneficiaries. Right, an arrangement. Let's have a look at that. In this particular case, there was a loan entered into between the Harm Trust as the borrower and the Standard Bank, the lender. And the agreement was signed by a trustee who also gave guarantees for that loan. What's wrong with that contract? There's nothing right with that contract. What happened over there is that the funds were made available to the trust, and then the funds were lost. So the Standard Bank sued on that agreement. The court laughed at them and said, you've entered into an agreement with a non-existing party. A trust is not a person. To make that valid, the agreement must be between the trustees of the Harm Trust and the Standard Bank. So they said, well, don't worry, we're going to sue the trustee because he signed personal guarantees. The court said, if your main agreement is null and void because it's a non-existent party, any ancillary agreement has to be null and void as well. So Standard Bank lost everything. So the point that I'm making is that if you don't understand what a trust is, you're not even up to starting blocks. And these are where mistakes are made in practice. It's a trust instrument, so there must be a trust document. So it doesn't apply to oral trust. Now, a very important section is Section 2 of the Trust Property Control Act. It said, if a document represents the reduction to writing of an oral agreement by which a trust was created or varied, such document will be deemed to be a trust instrument. So Section 2 of the Trust Property Control Act is saying we can have verbal or oral trusts. You see, the problem is, for example, you cannot enter into a contract as a trustee on behalf of a trust to be formed, because you haven't got the prior written authority of the master to act. And a stipulati altri, if it's a movable property, if you're using that form, I would suggest there's double transfer duty. But a verbal or an oral trust, you can then enter into an agreement, then reduce it to writing, and there you are, up and away. So a trust is an arrangement which has certain consequences. You know, people who got assets, they put them in trust, and everything carries on as before, you're wasting your time. That's an alter ego trust, and no legal effect will be given to it whatsoever. And so when things change, a trust is not suitable for someone who wants to keep control. The only way to be safe and sure in a trust is to have a majority of independent trustees. Move away from that principle at your peril, because you start moving these things together. Once these things are together, it's full ownership. You own the thing. So things do not remain as before once you've got your trust. Look at this guy. There has to be separation of control and benefit. Control and benefit. In this particular case, it illustrates, you know, people think when their assets are in trust, because they own them, it's their assets, and they put it into a trust, it's still their assets. Well, it's not. You've got to go cap in hand to the trustees and say, you know, I want to do certain things, please apply your mind. And that is one of the reasons why, if you've got a trust, which is discretionary trust, for example, discretionary trust can be very dangerous if you just have a whole host of discretionary beneficiaries. Because just because Papa put the assets into the trust, and he's one of the discretionary beneficiaries, doesn't mean to say he's entitled to the income. A lot of people think, because they were my assets, I'm entitled to the income, even though there are other discretionary beneficiaries. Because, as I've said on many occasions, children are absolutely lovely when they're this age. They get progressively worse as they go up like this. And they can become positively ghastly when they get married. Because how many happy family situations? We're a happy family. Now a new spouse comes along. Now that gentle, calm environment is shattered because the spouse sees money and then wants to get hands on money. So what we want to say here is that when there's a trust, things change. This guy was a very successful businessman. And he formed companies, and he had companies, and they did very, very well. And then as part of a financial plan, his financial advisor said, come and put your growth shares into a trust and sell them to the trust on loan account. So he's swapping a growth asset for a frozen asset, typical financial planning scenario, which he did. Then he went for a medical operation, which was a complete disaster. And he came out a third of his former self. And all that energy in the businesses and things like that dissipated. Now he sued the medical practitioner for financial loss. The court turned around and said, you've suffered no financial loss at all. But he says, you know, I was energized, the businesses are now sliding into the ground. There's huge financial loss. The court said, there's no financial loss to you because the businesses are owned by a company. You don't even own the shares. The shares are owned by a trust. You're a discretionary beneficiary of this trust. You can't prove any financial loss whatsoever. Things have not stayed as before. The ownership issue. Have you got a Bevint or have you got an ordinary trust? Don't worry about if your trustee goes insolvent, because Section 12 of the Trust Property Control Act says that the assets are not held by the trustee for himself or herself, but in a representative capacity. Right, what are the problems with trusts? Thinking that trusts are not regulated at all. This is where I can attack so many trusts, where they're either not regulated, people think they're not regulated, or they're not properly administered, they're just a bit of a shambles. The way trusts are formed, and the way assets are put into the trust. Let me just talk on that very briefly. You know, how often do you form a trust? Either a founder of the trust put 1,000 rand, give you 1,000 rand to trustees to be held in trust. We, the trustees, accept. So there's a donation of 1,000 rand, the trustees accept it, and the trustee looks nice. The accountant's excited because there's a debit and a credit, and everything is on track. Did that money actually get paid over to trustees? Or are you pretending? Because if you're just pretending and there's a debit and a credit, the debit and credit doesn't create a transaction. A debit and credit must follow an actual transaction. So if this donation never even took place, the whole act that formed your trust never took place. Have you got a trust? No. You don't have a trust. But I paid it in cash, or just paid for expenses of forming the trust. No. Because Section 10 of the Trust Property Control Act says when trustees receive money, they shall put that money into a trust bank account. It's not a whim, it's not voluntary, it's a statutory requirement. So you see, trusts sometimes aren't even out of the blocks, and there's a problem. The way trusts are administered, trusts are highly regulated. We'll look at that. The way trusts are amended, simply because the trust deed says trustees can amend the trust deed, does not mean to say they can amend the trust deed, because the provisions of a trust deed cannot override the common law or statute, which we'll have a look at. And then taxation of trusts in the future, we won't get too excited about that. So thinking that trusts are not regulated at all. First of all, the Trust Property Control Act applies. Now, for example, who's got trust they've never read the Trust Property Control Act? Already got a problem. Because when an act says you have to do something or must not do something, believe me, there's got to be compliance. So take, for example, I was speaking to somebody the other day, he resigned as a trustee of a trust. I said, oh, did you? He said, yeah. I said, what did you do? He said, I wrote to the master's office and resigned, and I wrote to the other trustees and resigned. I said, well, guess what? You're still a trustee. And you're under Section 9 of diligence, skill, and all the rest of it. But I said, I resigned. I said, no. Section 21 of the Trust Property Control Act says what you have to do if you want to resign. You must write to the master, but you must also write to the ascertained beneficiaries. That's what Section 21 of the Trust Property Control Act says. And if you think you've resigned, but you're still hanging in there, you're still under your statutory obligations as a trustee, which is wrongful if you haven't complied with your duties. And if there's wrongfulness and it's caused financial loss, for example, to a beneficiary, hello, problem. The common law applies. We mustn't underestimate that we are not a codified nation when it comes to laws. We sit with statute, but we also sit within a sea of common law. But the law is the law. Your trust deed cannot override statute, and the trust deed cannot override common law, which we've seen recently in where someone tried to amend the trust deed. So, when you look at the Trust Property Control Act, there's certain things you have to do, certain things you must do. The common law applies. The trust deed is the constitution. You must comply with what's actually in your trust deed itself. The ultra vires doctrine is alive and well when it comes to trust deeds. Edwin Cameron says, outside the provisions of a trust deed, a trust will not be bound. So you enter into a contract with somebody else's trust. Have you asked for a copy of the trust deed? Because if you enter into an agreement which is beyond the scope of that trust, it's null and void in law, because the ultra vires doctrine does apply. If you enter into a contract with someone else's trust, you want to see what's in that trust deed to see if the trustees are capable of entering into this contract. Ignore that at your peril. Trustees hold an office. Don't be a silent trustee. If you've got your mate on the golf course, he says, I want you to be a trustee, and you said, fine, and he gallops over the hill and you never see what's going on in that trust, you are seriously acting wrongfully against a statute, and if there's any financial loss to any party, you will be personally liable in those circumstances. Because one of the statutory requirements for a trustee, you have to be diligent, which means you must be watching, you need to know exactly what's going on. All beneficiaries get rights. If you think with beneficiaries, discretionary beneficiaries, have they got rights? As I was going up to this scenario over here, that's where I was going, until I lost my train of thought, is that one of the discretionary beneficiary goes to the trustees who's now married and says, why are you just giving all this income to my father? I'm also a discretionary beneficiary. You must consider all the needs of all discretionary beneficiaries and then make an award. According to need, you've got to act properly. So my advice is, rather than just have discretionary beneficiaries, have classes of different discretionary beneficiaries. In the same way you have different rights of shareholders. You have preference shareholders, ordinary shareholders, deferred shareholders. You can have exactly the same structures when it comes to discretionary beneficiaries. When you're exercising your discretion, you first consider the needs of these group of beneficiaries. And then those, and then finally deferred beneficiaries only thereafter. But if they're all competing as equal discretionary beneficiaries, people think discretionary beneficiaries do not have rights. They do have rights. And certain laws applied. We're looking at trusts are regulated. This is really the point. So, for example, certain laws apply. For example, what is a South African tax resident when it comes to trusts? South African trusts and also trusts managed and controlled in South Africa. So, for example, if you've got a letter of wishes and you reside in South Africa and you're effectively in control of that trust, it's a South African tax payer, liable for residence-based taxation. So be very careful, you know, and you say, but I jump on an aeroplane, I've got this letter of wishes and I can tell the trustees what to do, but we're always going to meet in Luxembourg. Technical things like that, as Philip said earlier, don't work. A court will look at the substance of a transaction and substantive facts, not technical aspects. And the master has powers. If you can energize the master's office, They can be very useful when it comes to trust because they can, for example, cause an investigation to be held into trust. And that a master, if you go to the trust property control, it has considerable powers and it costs you nothing. You can actually utilize the master's offices to achieve whatever you want to achieve. The way trusts are formed, I've mentioned the initial donation, and the way trust assets are acquired. First of all, as I say, look at a practical scenario. 3 guys get together. They want to enter into a property transaction. And so they don't want a company because they don't like the Companies Act. They don't want close corporation because we can't have them anymore. So they say, no, let's use a trust. So the 3 of them get together, they form a trust. The 3 of them are trustees. And the 3 of them are beneficiaries. And they have the power to dispose of their interest in the trust. In other words, it's a classic, many business or trading trust are structured like this. And now they do the development, and it's a disaster. And the creditors sue them personally. They don't look to the trust assets only. They sue these 3 guys personally. They said, you can't sue us personally, we've got a trust. The court says, you've got a what? The 3 of you are trustees. You come together for a business purpose. You are 3 beneficiaries. Yes, but it's a trust deed. The court says you are partners. You won't tell us what you've got. We will tell you what you've got. And they held him personally and jointly severally liable for business debts because it was the end of the partnership. So there are problems when trusts are formed right from the start. Have you got a trust? You might have a registration number. The master's office is merely a record-keeping office. It doesn't give you any validity, a stamp of validity, when it comes to trusts. Clive waved at me when I must stop because I don't know what time we are now because Philip spoke for too long. So take, for example, a practical situation. I form a trust and I sell my assets to the trust on loan accounts. Okay, that's what you did. You swapped a growth asset for a frozen asset. Can I see your sale agreement, please? Oh, you haven't got one. Oh, gosh. Well, is it a sale? Okay. Can I see your loan agreement? Hey, you don't have a loan agreement either. Oh, my gosh. Now you've got a problem. Because what's the difference between a sale on loan accounts and a donation, which attracts 20% donations tax? A loan, there's a quantum, there are repayment terms, and it's interest-bearing or interest-free. And let's see what the terms are. In the absence of a loan agreement, if I was charged 20% donations tax, thank you very much. Onus is on you to prove otherwise. What you're going to do is get and make it up in the witness box as you go along. So these are basic issues when it comes to trusts. The way trusts are administered, this is where a lot of people will fall down when it comes to they think their assets are protected. Because the badness or the lack of administration. Have a look at section 17 of the Trust Property Control Act. It says, a trustee must not, without the written consent of the master, destroy any document which proves how assets, where the investment is, safe custody, control, administration, alienation, distribution, before the expiry of 5 years from the termination of the trust. You can't destroy those documents for 5 years after termination of the trust. Have you got these things during the existence of the trust? Well, you'd better have. And you know, safe custody is, for example, are the assets insured? That's safe custody. It's not just locking something in a box. So you've got to have proof of all of these sorts of things. So trusts can be very badly administered. For example, a trust operates on trustees' resolutions. They've got a trustees' resolution book. That's necessary. The way trusts are amended, cuts a long story short, I haven't got time to go into it, but basically, as soon as beneficiaries accept the benefits of a trust, they are party to that trust, and even though the trust deed says trustees can amend the trust deed, if the beneficiaries have accepted the benefits, you cannot make amendments without the consent of those beneficiaries. Put Hitler's case. Even though what the trust deed says, the common law overrides the trust deed. So one has to be very careful with amendments. The only issue is, when have beneficiaries accepted the benefits? And in my slide, but there's no time to go there, for example, discretionary beneficiaries who have received the benefit, the courts have said they have accepted the benefits. And now you can't amend that trust deed without their consent. So these are very important issues. Right, and then the taxation. Now, asset protection is, in my opinion, one of the most important things. Take, for example, I have to bring in a bit of company law here, because people form companies for what reason? Well, first of all, to do business, but also you want some elements of limitation of liability. You know, that's what I'm willing to risk, and I don't want my own assets to be at risk, so that's why I form a company. Have you read the provisions of this new Companies Act? Minister Rob Davies is special to us. There's a terrible section in that Companies Act, section 2182. It says any person who contravenes any provision of this Companies Act is liable to any other person for any loss or damage suffered by that person as a result of the contravention. Now, this is horrific, because, for example, one of the statutory duties in the Act is for directors to be diligent, skillful, diligent. So when are you actually in breach of the Act? If you're not careful, forget about fraud and recklessness and all the rest of it, you're in breach of the Act if you're just not careful, if you're not diligent. And if that has caused loss to anybody, it's not just employees, anybody out there, then you're personally liable. So, for example, if you open a branch in Cape Town and you haven't been due diligence and the branch folds and you have to retrench people and they've suffered financial loss, they say you weren't diligent when you opened this branch in the first place. Therefore, we're seeing you over here. And they also have class actions that only one can sue and represent the rest. So one has to ask the question, why am I talking about this? Because directors of companies and their advisors need to protect their assets. You know, for example, you look at the financial reporting requirements in the Companies Act. If there's not fair presentation, you're in breach of the Companies Act. And then if that's the bank manager is reading your financial statements of your client and now suffered loss, goodness, because the financial statements weren't complete, which they have to be, for example, you are wrongful because you're in breach of the Act, and the bank manager can sue you. So, asset protection. I'm now going to move very briefly, another 3 minutes if I may. I just want to look and mention where assets can be at risk. Excuse me. Okay. By the way, I don't like testamentary trusts. It's somewhere over there. Why not? I think, you know, for your clients, set up a trust while your client is alive. Because then they're used to, the family's used to the trust form. Rather than, you know, you read in the last will and testament and you're creating a trust at that time. It's full of risks. For example, take a practical situation. This guy dies and he bequeaths his assets to a trust. And the beneficiaries of the trust are his 3 children. And the terms, and it's a testamentary trust, his 3 children are the beneficiaries. And in terms of the trust deed, the children can't get any income until they're 24 years old. They can't get any share of capital until they're in their 30s. So in other words, he's saving them from their own indiscretions. And they're reading the will and the guy's now dead. You know what the 3 children do? They repudiate their interest in the trust. They say, we don't want to be beneficiaries. Now, if you don't have a beneficiary in a trust, it's a nullity. A trust has to have a beneficiary. They've repudiated their interest. There's no trust. Guess what? He dies intestate. Who are benefiting from the intestate situation? The 3 children. Why wait till they're 20 and 30? They get everything now. You see, they defeated the whole purpose of what he set out to achieve. I don't like testamentary trust for those sort of reasons. In conclusion, when are assets at risk? When there's no need to lift the corporate veil or the trust veil, because you're just acting so badly, treating those assets as your own. The court will say, this is an alter ego trust and we're getting divorced or the creditors are coming in, we will seize those assets because you're treating them as your own and we will treat them as your own. For example, how many situations do you have where a trust owns a house and the people are just living in that house? So I go to them and say, justify your occupation of this house. They said, no, well, we formed this trust and it's our asset. I said, it's not actually your asset, it's owned in the trust, it's owned by trustees. Justify your occupation. Went to court, and the court turned around and said, without a resolution of trustees giving them occupation, or without a lease agreement, or without something, they're treating those assets, that house, as their own, and therefore we will treat the house as their own. See, that is an alter ego trust. So things have to be in place. Then you get sham trust, like that partnership. You call it a trust, it's a sham, it's not a trust at all. Then you get where you can lift the corporate veil, the trust veil. We've seen this where there's an unconscionable abuse in company law of the company's form. Same principles will apply to trust, where there's an abuse of the trust form. For example, I've got a whole lot of creditors and I want to go and hide my assets from those creditors, so I form a trust and shove them in there. That will be an abuse of the trust form because the rights have existed against you, and now to defeat those rights which existing people have, you go and put your assets and scurry them away. It won't work. And the fourth one is very interesting. I'll just give a practical example of what happened. There was a husband, wife, and a trust. The trust owned farms. The husband, wife were farming the farms. Now the husband and wife got divorced, and she didn't sue him under the accrual system. She used this very unique argument. She says, there's a husband, wife, and there is the farms in a trust. We have a partnership. The three of us, a universal partnership. Now we're getting divorced, there's a dissolution of that partnership. What happens when there's a dissolution of a partnership? You share the assets of that partnership. And the only reason why she did not win, the court said you have a valid argument. We do recognize a universal partnership. But the only reason why you're not going to win is because of the terms of the trust deed. The trust deed was drawn up and established by his father. And specifically in that trust deed it says the assets of this trust will never form part of any partnerships. And that's the only reason why she failed in her argument. Thank you very much.